morning, everybody. Welcome to our 37th episode of Cannabis Live. I'm pleased to be sitting amongst my colleagues, Travis Copenhaver and Nick Galendez. You may notice we have an extra body here with us today. We'll be introducing Nick here in a few moments. We're excited to have him join the firm, so good to have you here. We'll let you introduce yourself here in a moment. Today we're going to be talking about properties, but before we get too far into it, we just want to ask you, like us, share us, ask us questions, comments throughout the show. We'll do our best to answer them in the show, and if not, we'll answer them after the show. A few other items of housekeeping. You'll see in the bottom, I guess, right side of your screen that there are a couple of links there. First is to our municipalities page. We are going to be talking about property today, so that could be a great resource to go to if you're looking for properties compliant in the state of Michigan. The other thing is right below it is a YouTube link. We'd love to have you subscribe. We're now able to post our Facebook Live shows on YouTube, and we'd love to get more people watching and asking questions and whatnot through that means.
If you ever miss a show, all the shows are up on our YouTube there.
That's right, and we also have them on our website, of course, at cannabis-related.com, and check us out on Facebook at Cannabis Legal Group. So welcome to our show. I guess now's a great time to pop your cherry there, Nick. Tell us a little bit about yourself. Introduce yourself to our audience and let them know who you are and how you got to the Cannabis Legal Group.
Well, good morning, everyone. Thanks for joining us. Like I said, Craig, thanks for having me and Travis. I'd like to thank Barton for bringing me on. A little bit about myself. I was born in Hawaii, lived in Las Vegas for a while. Eventually made my way to the great state of Michigan, despite the cold weather. Ended up going to U of M for undergrad and went to Michigan State Law. Got my license in 2015, and I've been kind of a cannabis attorney since I got my license. Travis and I both worked at the same firm in the cannabis space. Mostly kind of worked on civil litigation under the MMMA and just education and advocacy and local licensing.
Well, and we're really glad to have you on. It certainly adds another really great brain to the crew here. As you know, he's a mixed bag between Michigan and Michigan State, so both Travis and I picked up half of a common
Trying to balance off the opposite.
That's
here.
right, and Barton and I got the MSU side of things down as well. As we talk about property, and Nick already pointed out, he's done a little bit of the municipal work, to say the least, as has Travis. So, Travis, tell us a little bit about just, setting up municipal, reviews and then we can talk about the kind of work that you and Nick have done and get
Sure.
into the weeds a little bit on that.
So obviously we all know that the municipality you want to put your property in, so you can facilitate one of these licenses, has to participate in the MMFLA program. And what that requires a municipality to do is to pass an ordinance saying that yes, medical marijuana facility businesses can be in that community. But it's usually more than that. Once they've decided whether or not to participate, then they do a lot of things. They say how many of each license type there can be, and then more importantly, where those licenses are allowed to be. In some communities, you'll have one ordinance, in others, you'll have two. What you're breaking down is what we call police powers, or the authorization of the business itself. And then what we have is zoning for those businesses. And that's probably what we're going to focus a lot on today is, your community is participating in the Medical Marijuana Facilities Licensing Act. Where can I put one of those businesses? And the first place you need to look is whatever zoning rules they lay out in their opt-in ordinance. Usually, you're going to see things like by license type, and there's the 5 licenses. What zoning district can you be in? Do you need to be buffered from sensitive uses like schools and churches? Are there square footage requirements? Are there parking requirements? Are there beautification out of blight requirements? Are there types of color you can have? Are there sign restrictions? All of that's going to matter because even if you have a building in the right spot, it might not be the right building for you.
Yeah, so what we know from the MMFLA, and we've talked quite a bit over the last 37 episodes about different opportunities in the property area. And the reason we keep coming back to it is you cannot operate, obviously, without a property. Your license requires a specific location with a specific ordinance allowing you to be authorized locally, and then you can go ahead and get approved with your facility plan, everything at the state level. And as we do that, Nick, tell us a little bit about what your interaction has been when you let's talk about a community that has not done a thing. Mm-hmm. Somebody walks in and says, "Hey, I'm in this town, we'll say mid-northwest Michigan. nobody's there right now. There's no ordinance. We contacted the city. What happens next? Walk into the steps as to what you're hearing back as you communicate with these towns.
Well, definitely, it's kind of the most tasking topic when you're doing it, and you're looking, a client or a potential client will come up to you and say, "I'm interested in this area," and they don't have an ordinance. I'm looking at properties, and then they want us to kind of look through and search for those without having any kind of guidance from the municipality as far as what zoning districts and buffers that are kind of going to be required. So at least, we know in the MMFLA that there are the, to be a grower, you need to be in an industrial or agricultural zone. But other than those little parameters, it's kind of hard to pinpoint exactly where they're going to be, or where the city's going to allow them, or township or village. And it's a lot of property speculation. There's definitely certain sensitive uses that you can kind of look as guidelines. There's a lot of parameters like that really kind of, as you look through them, and I've looked through thousands of properties, and it gets tedious, but I think I'm really good at it, and I take passion in, trying to locate different locations that might be good for potential licensees. So it's definitely kind of a work in progress. You need to pinpoint your specific areas where you think it'll be good for a location.
And so what we have here is that, there's a lot of, we know a lot of the urban communities have really good websites. And within their websites, you might even have links to their zoning ordinance as well as their zoning maps. In other more rural areas, we've seen a lot of smaller communities that may not have a lot of online interaction. But the personal touch is really the part of it, I think, that can actually set our advocacy apart from those that are just trying to touch it from afar. So let's assume we have an ordinance or a community that, when we look them up online, it's very bare-boned, type of setting. Who do we call? Where do we go? How do we interact with that town in order to figure out what the next step should be?
Well, I think the first thing to do is if you have any sort of personal connection to that town, you lean on your connections. But in the event you don't, usually the first person you go to is the city manager if you're in a city, or the township supervisor if you're in a township. Those are administrative staff that typically are kind of the ones who know exactly what's going on and everything in that community. And a lot of these communities are already considering what they want to do with the MMFLA. So to kind of get an update on what kind of conversations have happened to that.
Well, it looks like we may have lost our connection there for a moment, but technical difficulties aside, moved ourselves back to the big conference room, so I guess we're running into a similar challenge. Also, if you can't hear us very well, please let us know by indicating as much in a comment or whatnot. We are sitting a little bit further back from our microphone today, so looking at the gauge, I think we're doing okay. But let's get back into where we were before, and you were discussing communicating with the township.
So different cities, different townships, the size of them are going to lead you in different directions. On smaller communities, a lot of times their administrative staff, their elected officials are working at a more part-time basis. So figuring out who really is the one that's going to be stuck with deciding how this community is going to interpret the MMFLA is going to vary from place to place. In some communities, it might go to one of the trustees or one of the city council members. In others, it might go into a planning department or zoning department to put a draft together. Other communities might lean on their municipal attorney to do the draft work. A lot of communities are now able to look to the ones who've come before them and pull some examples to repurpose for their community. So trying to get an idea of who's working on that project, or if there's going to be public hearings in the future, so that you can get up to speed with that specific community about what they're doing. Once you have an idea where they are and what their leanings are, then it's time to potentially explain how what you want to do is going to be of benefit to that community, so that you can ensure your location or your proposed location isn't going to be accidentally excluded by a different zoning criteria they may or may not put in place. The important thing to remember is every municipality could potentially have a different set of rules. So when you go from one community to the other and you're deciding what are the zoning rules in this community for a grower license, they could be wildly different. Not only in locations that qualify, but the criteria about how to be an applicant for one of those locations. And understanding all of the challenges, or where those challenges are starting to head towards, is going to put you in the best position to make sure your location is going to be included.
So, Nick, we got a call from a client. She's looking for a town that we haven't had any interaction with. From all of our initial research, they haven't had any, discussions on the MMFLA. But she's still interested in having you research some properties itself. So, walk through that process. Let's assume that we need to make assumptions about where these would be. What are you looking at when you're looking at the zoning map, and how are you trying to then provide advice to the client as to what properties they should be targeting, at least speculatively, until we can get further information?
Definitely, without an ordinance, there's a few things and a few guidelines you can kind of pinpoint for the more retail provisioning centers. Obviously, there's going to be, in the commercial districts or in the industrial districts. But beyond that, a lot of the places are going to be industrial for all the other 4 licenses, and there's a few, community organizations that are nearby, sensitive uses, public properties, federally owned properties like airports, and then just any kind of big businesses or kind of organizations that do have a lot of leverage. And we've had personal experience with this before, where a client who did satisfy the zoning ordinance ended up, getting a little pushback at public hearings and certain things like that, where they came in and kind of shook up the planning commission, and whether that was truthful or not, and actually threatening to leave if this place were permitted here. There's just certain things that just satisfying a zoning ordinance, if there is one, and if there isn't one, it's, as I mentioned, it's speculation, where you kind of have to have certain parameters to guide you by, certain things that you would think, okay, that, this is a high traffic area, it's good, it's in a commercial location, there aren't a lot of residential uses nearby, and there's, not a lot of parks nearby, not a lot of schools nearby, and sort of those things, especially without an ordinance, where you'll have to kind of figure yourself in this.
And so in many of the ordinances, we know that there's what's referred to as a buffer zone. And just a general description of what a buffer zone is, in the ordinance it says you must be 1,000 feet from a school, or 1,000 feet from a church, or 500 feet from daycare. And so these buffer restrictions are things that are, linear, and we're looking at basically a 2-dimensional page online and working with that. And so there's some tools that we can use that can help assist us at least start to determine if something is red, yellow, or green in terms of how close it is to schools. What kind of tools are we looking at, Travis?
Sure.
Talk a little bit about how that would work.
Well, the most useful tool, honestly, is Google Maps. You just put your property in, you start looking around what's there. You should be driving around as well, because Google Maps are not 100% accurate. But, it's going to give you a really quick evaluation on, okay, here's the address, here's the building. You have a little measurement in the bottom, so you can kind of get a rough idea about how close everything is, and see, well, what's around me. More sophisticated than that is most counties in Michigan have what's called a graphic interface system, or GIS map, where you can put in your address, and it'll tell you the owner, the parcel number, square footage a lot of times. And then some of those GIS from community to community will have measurement tools, and you can draw circles around your map that actually accurately measure 500 feet from your parcel line and things like that. You can also verify that businesses that appear to be in Google are still the ones that potentially own those businesses if they're too close to you. Those two are usually on the public side of things, the easiest way to get some distance evaluations when you're thinking about things like buffering zones.
So it's important that we recognize, too, though, that even on GIS and Google, the Earth is a globe, obviously, right, and we're looking at basically a flat line. And so just because we think things might be 985 feet away, actually walking it and using an actual measurement on the ground or doing a formal survey are really the ways to finalize exactly how far you are. But this gives us a good footprint to work with so that we can give advice about the likelihood of success or not with the clients, correct? Before
you go out there and hire a land surveyor or an architect to give you the actual measurement, which is going to cost you money, you can get a rough idea of, if you're looking at 495 feet or 300 feet. If you're looking at 300 feet, you're probably within 500 feet. 495, who knows? You probably want to get an accurate measurement.
And also, to confirm the right zoning, you can always call the town or city clerk, and they're usually happy to provide you with that information. And then just one other little important thing to kind of remember is that pinpointing exactly what municipality the property's in. Oh, yeah. There's a difference between the jurisdiction that it's actually located in the municipality and the zip code. And how that happens is that there will be some smaller communities that don't have a post office in them, and so they'll be serviced by a larger kind of city post office.
Your mailing address, especially when you're in a township, is usually not the actual jurisdiction you're in.
Yeah, it's not as relevant as one might think. In fact, the best example of that is Bangor Township, Michigan, which we know has had a very proactive marijuana ordinance now for the better part of 6 months. They've actually gotten many licensees approved that are going through the state process now. But what's very interesting is that if you look at their town hall address, it's actually listed in Bay City, Michigan, even though they're directly across the street. And so that's just a great example of don't just trust the mailing address. Actually do the next step of due diligence. There's actually a number of communities around our state where you're in a township or a city, and it's actually managed by a different township completely. In fact, they might not be a chartered township, and therefore or an incorporated township, and therefore they might actually be, you could be living across the street from somebody who is managed by one township, you're managed by another, but you both have the same quote-unquote city address.
Another thing that happens too is there's a lot of times unincorporated villages within a township where people will think they live in the village of whatever, but you're actually in something township. And effectively, the jurisdiction that has the ability to pass the types of ordinances we're talking about is the one that needs to pass an MMFLA ordinance. So you might be locally in some village in a community in Michigan, but you have to go to the township hall and get the township on board for whatever your project is.
Yeah, and there's a good example that we can say, just from a client of ours that recently was looking at property in a township outside of Flint and believed that the township was actually in the city. Went to speak with the city council, or I think maybe somebody within the mayor's office, and came to learn that that property was completely in the township next door, even though they share the same name. I don't want to talk too much about the exact township for the client's credit. But notwithstanding, I think that those are important features. Now, Nick, let's flip the script a little bit, and let's talk about a client who has a property. And they're contacting us because the community that they're in has not yet adopted an ordinance. But they have a property. How do you approach it first? I mean, are you looking at kind of seeing where the property is, a buffer, and then trying to figure out what the township may or may do with that? Like, walk us through. A client called and said, hey, I have this property on 123 Main Street. I want to use it for a cultivation and processing facility. Help me out.
Now, was that with them having a draft ordinance? Or
no, there's no draft ordinance yet. This is just purely a brand new town, and somebody already has property. We're not speculating there. We already have the property.
I'll definitely just at first just kind of go through the steps, grab the zoning map, go on the GIS, use Google Maps, kind of try to pinpoint, okay, is this place in a commercial or an industrial, depending on the license. Then kind of, use little benchmarks, parks, schools, residential areas, just kind of know what we're looking for, what could be in an ordinance potentially in the future. So that way, if that particular client wants to have us go and lobby the municipality, try to get an ordinance passed, we present them with a draft ordinance, or kind of try to find something we can present to the municipality that'll fit for that property, and just kind of being sensitive to those other uses around too that might not necessarily be something that the city or township prohibits, but something that in a special land use hearing going forward would be something that if they rally the troops and send a whole community organization over, and they have very valid arguments to contest that being there, but just kind of want to minimize your risk of having that location, especially if you own the property, actually getting denied for various reasons.
Yeah, but in general, so a client comes in and says, well, I'm interested in using this property, and just from a cursory view of it, they're kind of close to a school. Our advice has to be, of course, you're close to a school, and it's not likely that we're going to be able to work with that. Let's start looking at other areas nearby, because I think we have to be very realistic with some clients. 380 feet away from a middle school, the chances of them getting licensed in that spot locally is very slim. I mean, that's true, isn't it?
It's true. Most communities are putting a buffer in at minimum for schools, but it's not required. Each community can zone however they want to. But you'll find there's some trends, and that's what we do when we're looking at a community that hasn't done anything yet. We see, most communities are sensitive to these uses. How close are those? Most communities put these different license types in these types of zoning districts. Which one are you in? And then beyond that, the most important thing you'll need to do when you have this license is be a good neighbor. You need this community to do something nice for you. They have no obligation to do so. So if you're a thorn in their side, you're an annoyance to them, they're less likely to do something to your benefit. So, and that applies not only to your elected municipal officials, but also to the neighbors surrounding you. So when Nick says, be careful about what's around you, maybe it's not a church, maybe it's not a school, maybe it's a non-profit facility, or a big big anchor business the community depends on, well, you don't want them against you, because if Ford Motor Company, for example, doesn't want a marijuana business next to them and they throw their weight around, the community is probably more likely to take Ford's side than yours.
I just want to address, we got a couple of questions there. Diane, thank you for yours. And Phil, thank you for the comment. We appreciate that. We try very hard to provide very good content and certainly make it as available as possible. We are an open book that way. So go watch our other 36 episodes and you'll see that from us. Diane, you asked a couple of different questions that I think I can address pretty quickly. Number one, the state doesn't have any limit on the number of licenses. So community by community, as we're talking about these different ones that have opted in, some of them we can look at. They do have very limited numbers of licenses. A good example of that, the city of Lansing has an ordinance that limits their provisioning centers to 20 to start, with the addition of 5 more after, of course.
Sorry.
I knew that. But the original ordinance is 20 with 5 more later. But that's a limited area. We compare that to, say, Ann Arbor, which is saying that as long as they're 600 feet apart, they'll allow as many as can fit into the community. So those are buffer restrictions, but not a limit. If we added up all the different communities throughout the state, that's the number that the state is going to allow for. With regards to the illegality of the federal law and everything else like that, what I'd refer you to is we did a few different memorandums that on the Cole memo and a few other things addressing the federal exchanges and whatnot. What I will say is Michigan has created an immunity for financial institutions under its new technical fix under the MMFLA, and so we're hoping banks will be on board very soon to answer that question. But let's flip back into our property discussion. So now we have a property. Client says, "All right, I'm interested in it." The ordinance or the community that we're looking at, the property's not near a school. We don't have to worry about things like that. What happens next? Like, we want to communicate to the township. Are we going to their meetings? Are we trying to sit down with them privately? What would we be doing in the advocacy component of that, Nick?
I definitely think you can approach it from both ways. I think a phone call, especially if you have a property in the area, they'll kind of, be more accepting of you, where, versus sending somebody out and say, "Hey, I'm interested in buying some locations here. I haven't yet." I think actually having a piece of property and then, the actual property owner reaching out to that municipal official means, it means a lot more to them. Shows a commitment to the municipality. The other approach is obviously we can go to meetings, either in public comment portion of it, and just announce that we have a client, or we're here with our client, and we're interested in pursuing a license from the state for this type of activity.
Yeah. What I can say is just from in my experiences when we're walking into townships where we're saying, I represent somebody who has property here. In other words, we're already here. Now we want to use the property the way they wish to use it, as opposed to we represent people interested in your town. Maybe they'll buy here, maybe they'll come here, but you need to do more work first, and then we'll figure that out. I think that the former, the first step part, where we actually have property in hand, generally will carry a little bit more weight and give us a little bit more, I think, strength in speaking to them. And Barton asked a question I think, Travis, you can address, which is, of course, what do we do with provisioning centers and how our communities are addressing that? I think it's fair to say they're not a good fit for every community. Right. Why is that the case?
Well, it's important to remember that, as obviously most of us are big marijuana business advocates, marijuana is still controversial. It's not for everyone. People are going to potentially need to make compromises to even take this first step into a new medical marijuana system. And some of that compromise is being realistic. There are 5 marijuana businesses. One has a very direct impact on your community. There's sidewalk traffic. There's a point of sale where medical marijuana patients are purchasing actual for-use products. The other 4 licenses are really just business to business, either manufacturing or services, all in the furthering of actually making safe products available for patients. So when you have a lot of these communities, not only are they usually provisioning centers are the ones that are the most restricted or allow the least amount within a community. They're also zoned significantly heavier in some cases than some of the other license types. And as Barton mentions in the comments, are the typically desired in downtown areas. Some communities, but not all. And some communities don't allow any provisioning centers. They might allow unlimited licenses, but 0 provisioning centers, and to varying shades of allowance. So you might have a provisioning center in your community, but instead of having it on Main Street, they might want them out in industrial or more secluded areas to not really make that character impact on their community.
Yeah, and I think that's very true. And Phil, I appreciate your comment talking about building relationships. That's what it's all about.
Exactly.
Remember that when you're licensed, let's assume that we get to the point and you're in part of this community. We want our clients and everybody in this industry to be good corporate citizens. You got to engage your community. You got to be proactive in your community. You got to build relationships so that you can maintain a long-standing business relationship with that community as well. So certainly from day one, it's all about introduction and making a good impression and being forthright and completely transparent with the community. If you're going in there thinking, I want to do, I'm going to grow flowers. What do you guys think about a greenhouse over there on that agricultural property? And meanwhile, you're really there to talk about cannabis. At some point, they're going to pick out that you weren't as honest with them up front. And so build a relationship on trust right from the beginning. We don't have to hide in this industry. This is now a commercial license, and we are looking to be proud to be doing what we're doing, even if our cultivation is discreet in the back of the community that we're talking about. And so I think that that's very important. Kurt, you point out, some buffers with respect to residential areas. Certainly that's come up. Battle Creek and its ordinance has that as well. We're expecting to see that in Warren when their final ordinance comes out. Well, what do we do? There's a quote-unquote variance process. You've got a lot of experience in the litigation side of things. Talk about what it means to go through a variance and everything like that.
Well, typically you'll appeal a decision from a building department and take that up to what's called the Zoning Board of Appeals. And they'll hold a public hearing, and there'll be probably anywhere from 10 to 20 factors that you have to prove to them as to why they should allow you to have a relaxation of the requirements under the ordinance. A lot of that is consistency with the master plan. It won't be injurious to the uses around it. It won't be detrimental to the aesthetics of the neighborhood. And there's a checklist that you'll go through, and you need to have a majority of the vote of the people on the Zoning Board of Appeals in order to get that relaxation from the actual ordinance requirements.
And then each municipality has a slightly different way to go about its variance process, so it's important to understand the local politics and the local means to get the end that you're looking for. And that's why discussing it with township managers and supervisors and people in the know, zoning administrators are also another great resource to work with as you're going through locally to figure things out. It's very important.
To piggyback off of this, I think something you need to be realistic as well. A variance is an exception to the rules they've set out. So if a community has just passed a brand spanking new ordinance, it is very unlikely they want to start making exceptions to that ordinance because they've just spent a bunch of time deciding what was right for their community. And if you don't fall within those rules, it's going to be a very tall order getting them to make some sort of exception for you.
Yeah, and I think it's very important, too, that if the buffer issue is related to a business or something that you're seeking the variance on, you got to communicate with the defective person, or if it's a residence, knock on doors, talk to people, get permission, walk into that hearing for that variance with the approval of the people that would otherwise be objected to based on the buffer. And that'll go a long way too. So again, communication, transparency is going to be a big part of it. And certainly that is something that we're going to see continuing to progress as what we have today is maybe a smattering close to 20% of our communities, that are dealing with it right now. But, I think we have a lot more work to do over the course of 2018. Kurt, you're asking whether or not townships and cities have given special use permitting differently, and I think that's actually yes. So why don't we talk a little bit about our experiences in SDU hearings?
So first of all, there's different ways to have those hearings, but beyond that, not every community is going to require these licenses to even have an SLU hearing in the first place. Cities like the city of Kalamazoo, where we're currently drafting an ordinance, have instead treated it as a permitted use with very stringent requirements, primarily on location and buffering. But should you find a piece of property that fits their criteria, it's not SLU at all, it's permitted use. You go, you show you have the property where it's supposed to be, you meet all the factors, they give you your attestation, you go to the state. In other communities, there's a lot of different ways to decide what you need to do. And in most of those cases, you're going to go into an SLU hearing.
Yeah, and in these hearings, in essence, sometimes the criteria is very detailed. We know Buchanan, for instance, has a much more detailed ordinance than some other communities. And so what you're required to provide in terms of the detail of your plans could vary between the two communities, even in the SDU process. And so, Nick, let's talk about, the big elephant being the city of Detroit. And I recognize, of course, for everybody's benefit, Detroit has not adopted in yet. We have a ballot initiative that was approved by the citizens. It's held up in court right now. But we do have a back-end understanding as to how the city has previously dealt with these. And I think that experience can kind of translate out into what we can expect in other places. And let's talk a little bit about how that process ended up from BC to BZA, for instance.
Well, definitely in the actual appeal application, it allows you to line out all of your arguments for why you meet those particular conditions for granting a variance. And it's really important, if you do believe you should have a variance, to really explain all those out in really in a thought-out way, hitting all the points. This kind of also can bring in the fact that and the importance of actually reaching out to the community. If you have people on board who are at, if there's a liquor store too close to you, you reach out to the liquor store owner, have them write a statement saying that they approve of the use nearby, having that in your packet of materials to give to the actual BZA or zoning board in that packet. And then definitely just having a good showing. They take testimony there as well, and they allow people from the community to either in support or negatively against it.
Whether you're in Detroit or some other community, you're typically going before the Planning Commission. They're going to have reviewed your application materials, whatever those materials were required to be. And then in most cases, the various commissioners are going to ask you follow-up questions or potentially require you to satisfy some of their concerns. So being prepared in these meetings as well is very important. When you walk in, if you're relying on your application, they already have it. Their job was to read it. Whether they did or not is going to depend on commissioner to commissioner. But if they have concerns about your location outside the black and white letter of the ordinance, that's within their ability to determine whether or not those factors should result in an approval or not. And anticipating what some of those concerns are going to be is very important. If an ordinance says nothing about how close you need to be to residential, then on paper, you can be wherever you want in that district. But if a community's commissioner happens to live in one of those houses 20 feet from you, he might be very concerned about what exactly you're trying to do. And if his vote's important, well, you got to satisfy him. That might not be something you think about if the ordinance itself is silent as to how far away from residential you need to be. There's a...
Oh, sorry, Chris.
That's fine.
There's also degrees of kind of success. If you have 4 or 5 churches and parks and liquor stores, it's almost a lost cause to do it. It's definitely, if you want to go ahead and challenge that, it's something it's well in your right to do. But it's a lot easier for the board to give you a relaxation of the variance requirements or ordinance requirements to get a variance if you're maybe if 1,000 feet away requirement and you're 990 feet away versus if there's a church and a liquor store and they're real close to you. So it all kind of depends to as far as how willing they are to even give a relaxation.
Yeah, and I think we also look at what obstacles are within that linear distance as well. You might be 800 feet away from a high school, but there's a huge ravine and a big forest in between, as well as a huge fence or in some instances a freeway and an overpass. So those kind of obstacles will allow you to utilize more obstruction in that distance, and that again is a way to try to get that variance request. The last piece of advice on that I think is important, and we've seen this through a number of different communities throughout the state, is deal with the planner. Don't be afraid to walk in with your plans and sit down with somebody at that municipality whose job it is to help plan the development within the community. And so take your plans in, be communicative, transparent, ask advice on it. To the extent that they can tell you, this will be approved by the commission, you won't get that per se, although they'll be honest with you about the likelihood. But at least you're not showing up day one for the first time at that hearing with no relationship with anybody on that board, no ability to say, I talked to Joe in planning committee, from the planning department, and we worked on this together. And I think that actually goes a long way to helping to get the board to relax a little bit, to really take you seriously, that you're not there just to, showing up that one day begging them for help versus working behind the scenes to really have a real solid plan that is kind of set up to be approved.
Right. And remember, your community, depending on the size of this community, a planning commission, a commissioner, is probably some resident of the town or the area that's volunteering his or her time to be on this committee. They rely on their planners, their zoning officials, their administrative team in the community just as much as you do. And if they are putting in a couple hours a night for their community as a commissioner, they're relying on their zoning department, their planner, to get some insight for themselves. So if you develop a great relationship with those administrative team members and they support you, that's going to go a long way in convincing the actual commission to support you as well.
Well, we've talked a lot about property today, and the biggest truism of property is location, location, location. So do your due diligence, be smart about things that you're locking up. It is completely okay to get into contracts that are contingent upon things like township approval or ordinance approval, or I think some people have gone so far as to seek out state approval. The challenge with that, of course, is how long will a seller want to tie up their property from sale, waiting on things are outside of your control. But that's part of the negotiation, and that's why it's important that you know what your terms are within your city. You know what kind of timeline you can expect based upon talking to planning. Oh, it'll take 2 weeks or 4 weeks to get on onto the agendas, and therefore we need that much more time for approvals. And so we got to always build that into your contracts and the things that you're doing on the front end, so that the back end can be the result you're looking for. Well, we talked a lot about property today. Nick, it's great to have you aboard. It's been a wonderful experience since you joined the firm. We collaborate a lot. We talk a lot. We're always, looking for questions and talking about our industry. We're all very passionate about it here at the Cannabis Legal Group. And, we'll be doing many, many more of our Facebook Lives, I think. So get used to our 3 mugs at some point here. Our beards, huh?
Yeah, I like it.
Yeah, but
I got to catch up here.
Yeah, that's right. I don't know how I can do that. But notwithstanding, I guess we will see you. We do these every Friday. Next week, I think we've kind of already talked a little bit about considering dealing with what does the application look like and what should we be doing with that. I think Stephanie has asked a question.
Yeah,
so.
It seems like pretty pertinent. Let's try to hit that real quick. So she's asked, what are some items that a buyer should be careful of when it comes to utilities, vacant land, etc. Great question, because while you might have the perfect spot and it fits whatever zoning language they put together, does not mean that's a good spot to set up your business. Think of provisioning center. You might come into that community with open arms. They love you, welcome. But if there's no patients within the 50 miles around you, how are you going to stay open? The state might let you be open, the community might not let you be open, but how are you going to actually sell your products to anyone? If you're a grower, if you're growing indoors, you need electricity for your lights, you need water. If you're running seed to sale tracking program, you ran into this.
Yeah, you need internet access.
You need the internet. Not every community in Michigan has that yet. So what you should be doing isn't just seeing what communities let you be there, but thinking about what do I actually need to do my business. And having an idea of what those factors are might rule out property that other people might think are good pieces.
And in fact, that's one of the other reasons to be talking to the zoning or the city planners, because they know what the defects might be with these particular parcels. Power is a huge factor. It isn't accessible everywhere in the state. It does have a lead time of maybe as long as a year to 6 months to a year to get a new transformer or substation added so that you have adequate power for the license you're seeking. So understanding that is a very important part of the due diligence that you need to do. So in your contracts, especially when you feel like you got a great deal to lock up and you're worried about it being tied up too quickly, put those kind of contingencies in there that give you the out clause in the event that you don't get the access that you're looking for, not only for zoning compliance, but what if it's zone compliant but you can't actually function in your business there? Or you got to wait a full year before you can even start because of a power issue. The other thing on that too, if I may, and this comes from Consumer Energy's business development advice, the person who runs their development department, says contact them early. There's no reason they can't be involved in the planning for you, because they might be talking to other people and there might be a bigger move to bring in more power than you believe just for your lot. So again, be communicative with power, be communicative with your communities, and contact professionals to help you. Stephanie's with Brick and Mortar, and I'm sure she appreciates the plug for the real estate work that she does.
And I would just add too that there's, if your property's in a floodplain or it's a super fun site, that would definitely be a lot more kind of added costs to just buying a property.
Yeah, absolutely.
Don't forget you have to run these businesses afterwards.
That's right. Well, thank you again, guys. We've now, I think gone over our normal 30-minute time frame, but we really appreciate everybody's questions. We appreciate those that watch. Many of you may watch us after the fact. Don't be afraid to send a question to us through Facebook and or through our website. We'll do our best to answer that. And we'll look forward to bringing more content to you here on Michigan's Medical Marijuana Facility Licensing Act as we move forward. For Craig Aronoff,
Travis Copenhaver,
and Nicholas Galendez.
Thank you guys. Have a great day.
See ya.